$340,000 warehouse, a notarized will, a father who spent his final lucid weeks walking through every detail of his estate with his only child and never said one word about this. Then a certified letter arrived, and a stranger claimed that a dead man had promised him half of everything. The legal theory behind it is one most people never see coming. Here is the full story. In January of this year, a man in North Carolina passed away after a short illness. He left behind one child, his only heir, and a carefully prepared estate. The will was notarized, drafted in 2021 with a licensed estate attorney, and the language was unambiguous. A commercial warehouse unit, valued at $340,000, owned outright with no mortgage and no liens, would transfer to his child. Probate had been moving without a hitch. The transfer was weeks away from completion. Then came the letter, certified mail, from an attorney. On behalf of a man I will call Gerald, the father's former business partner. Gerald and the father had run a small logistics operation together from 2014 until 2020, when they formally dissolved the partnership by mutual agreement. The dissolution was documented. It was done, or so the heir believed. Gerald's attorney made a remarkable claim. Before the partnership dissolved, the father had allegedly made a verbal promise, a spoken agreement, to give Gerald a 50% stake in that warehouse. In exchange, Gerald supposedly walked away from the business without seeking compensation for his share of the company's equipment. No written contract, no signed document, no email, just words spoken in a room, allegedly witnessed by two people whose names did not appear anywhere in the letter. Put yourself in the heir's position. Your father just passed. You have been through probate. You have done everything by the book. And now a stranger is claiming half of what your father left you based on a conversation you never knew happened, backed by witnesses who have not even been named. The will says nothing about Gerald. The estate attorney has no record of any agreement with him. And in your father's final weeks, when he was completely lucid and reviewing the estate with you, he never said Gerald's name, not once. The heir's position is backed by documentation at every turn. The formal dissolution agreement from 2020 is in hand. The warehouse appears in the estate inventory as the father's sole property with no encumbrances noted. The estate attorney who drafted the 2021 will, a full year after the alleged verbal promise, has zero record of any competing claim. 4 years of professional silence from someone whose entire job was to capture exactly this kind of information. But here is where it gets genuinely complicated, because Gerald's side of this story is not nothing. Think about what he claims to have given up. If the verbal agreement really happened, Gerald walked away from a business without receiving fair compensation for his share of the equipment. He took a real financial loss, banking on a dead man's word. And now that man is gone. Gerald cannot confront him, cannot depose him. The only version of the truth that survives is Gerald's, and those two unnamed witnesses. There is something genuinely tragic about every angle of this case. A family grieving a loss. A former partner who may, or may not, have been quietly promised a 6-figure asset by a man who had every opportunity to put it in writing and never did. We cannot know if Gerald is telling the truth. We cannot know if the father simply changed his mind and said nothing. What we do know is that $340,000 property and an entire estate now hang on words that no living person can confirm. Before we get into the law, I want to ask you something directly. If someone promised you half of $340,000 property, verbally, in front of witnesses, and then died without ever putting it in writing, would you fight for it? Drop your answer in the comments. Because your instinct on that question goes right to the heart of one of the most contested areas in American property law. Let's talk about the law, because this is where the case becomes fascinating. Every state in America, including North Carolina, enforces something called the Statute of Frauds. The concept traces back to 1677 England, and it exists for one reason: to prevent exactly this kind of dispute. Under North Carolina law, any agreement for the transfer of real property, meaning land, buildings, or structures, must be in writing to be legally enforceable. A verbal agreement about real estate simply does not count. That is the default rule. But here is the counterintuitive part, and this is exactly why Gerald's attorney sent that letter. The Statute of Frauds is not absolute. North Carolina courts recognize a narrow doctrine called part performance. Under part performance, if a party proves they took significant concrete steps in reliance on a verbal real estate agreement, and if refusing to enforce it would amount to actual fraud, a court may enforce the agreement anyway. The keyword is may. It is rare, discretionary, and the bar to prove it is extraordinarily high. For part performance to succeed in North Carolina, Gerald would typically need to demonstrate three things: that he took possession of the property, that he made improvements to it, and that he paid consideration, meaning he gave something of real value in exchange. Walking away without compensation might satisfy the consideration element. But Gerald never took possession of the warehouse. He never made improvements to it. That is 2 out of 3 required elements that appear completely absent from his claim. Now let's talk about what that certified letter actually does legally. The timing is not accidental. Gerald's attorney sent it during probate, while the transfer is still in progress, hoping to create enough legal uncertainty to pause the proceedings. But here is what you need to understand. A letter from an attorney is not a court order. It carries no automatic legal authority. By itself, it cannot halt a probate transfer. At its core, it is a negotiating tactic, an opening bid. For Gerald to have any real chance of blocking this transfer, he would need to file a formal equitable interest claim against the estate before probate closes, or seek an emergency injunction to freeze the transfer while litigation proceeds. Both actions require a judge. Both require formal filings. And crucially, both require Gerald to put his evidence on record. That means identifying those 2 witnesses and submitting them to cross-examination. Those unnamed witnesses are the single most critical pressure point in this entire case. Their absence from the letter is a tell. The moment Gerald files, those witnesses must be identified, deposed, and cross-examined. Their relationship to Gerald matters. Their credibility matters. And the fact that an estate planning session held 1 year after the alleged promise produced absolutely no mention of Gerald or any encumbrance on the warehouse. That silence will be very hard to explain away. Consider what the estate attorney's testimony would look like at a hearing. This is the professional the father hired specifically to ensure his estate was documented correctly. If the father had promised Gerald $340,000 property, the moment to disclose it was during estate planning. Instead, the attorney drafted a will listing the warehouse as the heir's sole inheritance. No competing claims, no side agreements noted, nothing. An estate attorney testifying to that carries enormous weight. We are now at the moment where Gerald has a decision to make. Does he actually file? Does he put those witnesses on record and subject his entire claim to discovery? Because the moment he does, the heir gets to see everything. The dissolution documents are already in hand. The estate inventory is clean. The estate attorney is ready to testify. And the statute of frauds is sitting in the corner of that courtroom like a very patient referee. Here is the legal reality in North Carolina. Under the statute of frauds, Gerald's alleged verbal agreement is presumptively unenforceable. No writing means no enforceable contract. That is the starting position. To overcome it, Gerald needs part performance. And as we have covered, he appears to lack the possession and improvement elements that North Carolina courts consistently require. The legal foundation of his claim is extremely fragile. In a case where probate has proceeded cleanly, the will is notarized and properly executed, the estate attorney has no knowledge of any competing claim, and the only evidence supporting the challenger is a verbal allegation backed by unnamed witnesses. North Carolina courts would almost certainly allow the transfer to proceed. The heir holds a documented, legally executed will. Gerald holds a memory. Under the law, those 2 things are not equivalent. What did that letter actually accomplish? In strict legal terms, very little on its own. But it did one important thing: it put the heir on notice that a claim exists. That means the heir's attorney must respond strategically, ensure the probate court is aware of the potential dispute, and potentially file a preemptive motion to confirm the transfer. Ignoring the letter entirely would be a mistake. Panicking over it would be an equal one. The correct move is deliberate, documented, and calm. There is a broader lesson this case illustrates with painful clarity. A verbal promise made by someone who is now dead cannot be confirmed, denied, or given context by the one person who made it. This is exactly why estate attorneys exist. This is exactly why written agreements exist. The moment a promise about real property is made, even informally, even between people who deeply trust each other, the failure to put it in writing does not just create legal risk. It creates grief compounded by legal warfare. In cases structured like this one, the resolution typically falls into one of three patterns. Gerald files, loses, and absorbs the legal costs of a failed claim. Gerald files, creates enough litigation risk that the heir accepts a discounted settlement, not because they are wrong, but because legal battles are expensive and emotionally exhausting. Or, as happens more often than you might expect, Gerald's attorney sends the letter. The heir's attorney responds firmly citing the statute of frauds and the clean estate record, and Gerald quietly walks away. But here is what never fully goes away, the doubt. The heir will carry the question for the rest of their life. Did my father actually make this promise? Was Gerald quietly cheated out of his share? Or is this a fabrication by a man who watched a $340,000 property pass to someone else and decided to make one final attempt? The law can distribute property. It cannot distribute truth. And in cases like this, that distinction is everything. If this case left you with one takeaway, let it be this: the statute of frauds exists to protect you. If you are ever part of any agreement involving real estate, even between partners, even between family, even between people who trust each other completely, get it in writing. Every single time. No exceptions. If you found this breakdown valuable, subscribe to Courtroom Chronicles. We cover real cases, real law, and real consequences every week. And before you go, drop a comment. Do you believe Gerald? I read everyone.